Hello, my name is Jonathan Greene. I'm a VA-Accredited attorney. Today I'm here with John Kent, accredited VA claims agent, and Vittoria Marini, also accredited VA claims agent. Today we're going to be talking about higher level review appeal option. So John, you file your claim for benefits and you get a rating decision. There's something in the rating decision that you disagree with and you want to appeal it. What are your options and what is the timeline?
Yeah, certainly. So whenever you receive a decision that you don't fully agree with, you express disagreement with some portion of it, you do have one of three options. You can file a supplemental claim. You can go to the Board of Veterans Appeals by filing a notice of disagreement board appeal, or you can file a higher level review on VA Form 20-0996.
And how much time do you have to file that appeal?
You have 1 year to file an appeal on any rating decision in either of those lanes. You have a 1 year period.
Okay. And Vittoria, how does it work? John mentioned the form number, the 996, but how does it work? What are the mechanics?
So you fill out your form and you note all the issues that you disagree with in the rating decision. On that form, you have the option to elect an informal conference with the VA adjudicator, and you're also able to include some sort of argument statement of why you disagree with that decision. You cannot submit any additional evidence because that is the nature of this type of appeal, but you can submit additional argumentation.
And how is the argument submitted? Is it on the form or is it on something else?
So you can submit even essentially a Word document drafting specifically why you disagree with the VA's decision, and that should be sufficient at that point.
Okay. And so let's go through some of the pros and cons. So John, you mentioned you can go to the board, you can do a supplemental claim with new and relevant evidence, or you can do this.
Yeah.
What is, so you're not submitting new evidence. What does that mean? It's a closed record?
Yeah, exactly. So if you're not submitting any new and relevant information, you just believe that it should go higher level review, the record is considered closed. That just means that no new information could be submitted. So it generally is quicker to go higher level review because there can't be any new information submitted. There won't be any new forms. VA Form 4142 won't be submitted. VA Form 218940 won't be submitted, and VA won't request any new examinations for the conditions that you're expressing disagreement with.
Okay, and the argument that Vittoria referenced to submit with the 996, that's not considered new and relevant evidence. That's really more of a summary of why you think they got it wrong the first time.
Exactly. So you can use that argument to point to evidence that's already in the record, but it's not considered new evidence. It's more of an interpretation of what's already in the record.
And what's the benefit of having that informal conference, if that is what you select?
Yeah, so if you do go that higher level review lane and you select to have an informal conference, it does provide you the opportunity to speak directly with a more experienced adjudicator for VA, someone who has what we believe would be a better interpretation, better grasp on VA's rules and regulations to hopefully issue a favorable decision in the matter.
And are there situations where you would select an informal conference and ones where you wouldn't?
There can be situations where you don't necessarily need to request an informal conference part of higher level review, but I would generally think that we recommend to generally have that higher level review conference with that adjudicator. They can at least provide some information about what the record might be missing to result in a grant of benefits.
Yeah, it's always nice to be able to talk with an actual person about the case and why you think they got it wrong the first time. We discussed the informal conference. How does that take place? What happens prior to and during the informal conference, Vittoria?
So on the 0996 form, you can elect the informal conference. You can put your contact information, phone number, email address, and you can check off different times of the day that you would be available. Typically, VA will reach out to you via a phone call, trying to schedule that informal conference. Or they will try to email you. If you have a representative, they will reach out to that person because presumably they would be listed on the form and be conducting that informal conference for you. But it is a phone call with the person who will be drafting the rating decision, and it's just in the name. It's informal, so there's nothing formalized. You're not swearing in or anything like that. Just talking through the major points of your case.
And does the veteran attend if they have a representative?
They don't have to. Your representative can take care of that completely for you.
And so just a warning, if you are a veteran filing this appeal, but you have a representative doing this on your behalf, you will receive a text message about the conference that is not something that you need to attend. It's more of an FYI. We've had some confusion resulting from that. So John, what are the cons of going this option of a higher level review?
Absolutely. So while we do believe that higher level review is a fantastic option, there are some cons, as Jonathan noted. One, sometimes the record does require more evidence. Sometimes you do need that medical information, whether it's from VA treatment records, private medical treatment records. You could be lacking a diagnosis for a condition if you're claiming service connection. Sometimes the record does need more information in order for there to be a grant of benefits. Another issue that you do run into is that if you do receive that higher level review denial, you are going to not be able to file a higher level review off that higher level review decision. So if you receive a decision, higher level review that you do express disagreement with, you then are required to either obtain that new and relevant evidence for a supplemental claim, or you're required to go to the Board of Veterans Appeals at that stage.
It's a good point, John. So don't higher level review appeal a higher level review decision. So Vittoria, what happens if the adjudicator in the higher level review appeal option thinks that more evidence is necessary? What do they do with it?
So essentially they can take it out of the higher level review lane and they can find a duty to assist error, and then it would kind of be in a supplemental claim lane, which we have talked about in other videos. But this is essentially VA saying that they believe that they should do more development on their end. So that record will be opened up again, and you could potentially be scheduled for exams or have the opportunity to submit more evidence at that point, but only if that finding happens.
Okay. Well, thank you, John and Vittoria, for a nice discussion on higher level review appeal options. If you are interested in finding out more information, please check us out on our website, greene-marizek.com. Thanks again.